I'm unmuted. Welcome, folks. Thanks for being here today. For those who don't know me, I'm Mike Schreiber, Director of Engagement here at Sigler and a faculty member at SEAS. And it's my pleasure to introduce our speaker today, Oday Salim. Oday is the Director of the Environmental Law and Sustainability Clinic at the University of Michigan Law School. He's also a senior attorney with the National Wildlife Federation's Great Lakes Regional Center. That's how we first met each other as colleagues there. And Oday is an expert, and you're going to hear a lot of his expertise on environmental justice and law. He's got a lot of experience in water policy, and he's done work on wildlife issues as well. And I'm always really impressed with the breadth of knowledge that he brings and the fact that he, as you'll learn today as a lawyer, can both talk on the legal side of things, talk from a strong justice angle, and is always looking out for the preservation and protection of the resources. So I'm going to leave it to Oday here and look forward to your comments. Thanks.
All right. Well, thank you so much, Mike, for spearheading the invitation. I really appreciate your and Greg's hospitality today, and of course Sigler's hospitality. I think it's I've seen some of these talks, of course, online, and I've seen a lot of the speakers, and I'm really glad to be in the same company of folks who have come and spoken here before. I really want to thank Margaret as well. Margaret really helped on the logistics side of things and helped make all this possible. So thank you, Margaret. And I want to mention too that the talk that I'm giving today, a lot of the content of the talk is pulled directly from my environmental justice seminar that I teach at the law school. I teach that every year. I've been doing it for a few years now, and will continue to do so. The content for that seminar, of course, is largely developed in collaboration with law students. So I want to make sure that I thank all those terrific law students, my clinic students, my research assistants, and other law students who have been involved at the University of Michigan Law School, and actually from the program in the environment at the University of Michigan undergraduate program, who really helped put together a lot of this content over time, especially Neil Joyce, who was my research assistant this semester and really helped pull a lot of that content into the Great Lakes Focus presentation that I'll give today. I think, I've seen a number of these talks before. I think many of those talks, I would call them very closely connected with the work that you all do. I think this one is probably a second or third, order removed from the work that many folks do, but I think it's still important to understand because a lot of the scientific work that folks work on here is going to get inserted into advocacy work and policy work, and a lot of that advocacy and policy work is driven by these environmental justice legal frameworks that I'm going to discuss today. And I think my overall thesis for the talk, this would have been maybe even more necessary 20 years ago, even 10 years ago. Today, it might not be quite as necessary, but I think it still makes sense. Many people just still don't think that environmental justice law exists. Largely, that's because there is not a single environmental justice federal statute, right, that was authored by Congress and signed by the president. Definitely that does not exist, although Senator Cory Booker from New Jersey and others have been hard at work on getting an environmental justice law passed at the federal level. But just because that federal statute does not exist does not mean that environmental justice law does not exist. It doesn't just exist. It's nearly ubiquitous today. It exists largely at the state level and within the federal executive branch. So it doesn't have that federal congressional imprimatur quite yet, but it is significantly shaping the policies and advocacy work that happen all over the country, and especially in the Great Lakes region. And there are implications for that when it comes to research and science, because the research and science, of course, over time is going to get applied through a lot of those policy and advocacy frameworks. And so what I want to do today by the end of the talk is give everybody a really basic understanding of the environmental justice legal framework. What does it mean for there to be an environmental justice legal framework exactly? And I want to provide some real world examples of how environmental justice is shaping Great Lakes policy and advocacy. And of course, talk to this crowd about just how important it is for scientists and researchers to be thinking about environmental justice applications of their work. Not to say that you can't just do, basic and theoretical science without the end in mind, but if you know that end exists, then I'm sure that that can shape a lot of what you choose to spend your time on. So the environmental justice that I'm referring to, and I say environmental justice law, I'm talking about all the forms of environmental law. I typically think about environmental law as 3 buckets of law. There's pollution control, where we're trying to minimize how much pollution leaves a source facility and goes into the world. I'm talking about natural resources management law, right? So when we're managing resource and mainly allocation of scarce resources, we're talking about oil and gas and coal, and we're talking about water. We're talking about those kinds of things, wildlife as well, wildlife management. And I'm also talking about energy regulation, which is largely price setting. But of course, behind price setting, there are all kinds of decisions that have to be made about prudent uses of energy resources and making sure that consumers are paying the best possible price for their energy and for their other utility resources. So I'm talking about all 3 of those buckets of what we sometimes call environmental law. It's a little bit of a, can be a little bit of a misnomer. But that's what I mean by environmental. So what do I mean by environmental justice? There are all kinds of definitions. If I asked anybody in this room for a definition, I'm sure you could come up with one. The Environmental Protection Agency has a definition that I think is the most well-known one. The Environmental Protection Agency's definition is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. There are basically 2 variations on environmental justice definitions. There's one variation that basically starts today. And I think that's largely the federal government's interpretation, and it makes sense that it's the federal government's interpretation or variation of the definition. What I mean by it starts today is environmental justice definitions from the government, from state governments as well, and from some organizations basically say what happened in the past certainly got us to where we are today, but moving forward, we promise that there will be fair treatment, equal treatment of everyone, and we're going to get everybody involved in decision making, etc. And I think that there's another variation on it, which accounts for how we got to where we are today and tries not only to treat everybody fairly and equally moving forward, but tries to address some of the stark injustices that exist and the fact that many communities got a head start, an environmental head start, essentially, over other communities. And there is a reparative or restorative aspect to other definitions. My definition, I think, is even simpler. It's a spatial definition, although I mean spatial in the physical sense as well as the theoretical, metaphorical sense, I mean. So what I mean by environmental justice is simply that too often environmental harms are too close, too proximate to vulnerable and historically disadvantaged communities. I'll talk about how those communities are defined in a bit. But so environmental harms like pollution are too often too close to those communities. And environmental benefits, think of parks and forests and beaches and that kind of thing, are too often too far from those communities, either literally too far from them or too inaccessible by them. And so that's essentially it. There are benefits and burdens, environmental benefits and environmental burdens. The burdens are too close, the benefits are too far. And there are reasons for that. I'm not going to focus today on what those environmental injustices are and how we got to where we are. I'm just going to make an assumption that people are very familiar with many examples of environmental injustice and that people are generally speaking familiar with a lot of the root causes. In every community, those root causes are going to be different. They're different in every country. Even within our country, they're different in different regions. So I'm going to maybe bring that up here and there, but I just don't have time to focus on those things. So I'm just going to move ahead and discuss what I mean by environmental justice community. So if the environmental benefits are too far from environmental justice communities, and if the environmental harms are too close to those communities, who are those communities? It's a pretty long list. You're gonna, in policy, in actual policy, you'll see different terms for this. Sometimes you'll just see environmental justice community. Sometimes you'll see vulnerable community, overburdened community, disadvantaged community, small community. It's called something different in different statutes and regulations. But in general, these definitions refer to some combination of the following: people of color, low-income populations, limited English proficiency persons, persons with a certain disability status, in particular physical disability status, members of a Native American community. Those are broadly speaking the categories of people that are going to fit within an environmental justice community. So if the burdens are too close or the benefits are too far, they're too close or too far from one of these communities or some combination of these communities. And what that means is, there's I think a misconception that environmental justice is about densely populated urban areas and the people of color who often reside in those areas. They reside in those areas for a reason. They reside in those areas because of the geographic racism of the 19 teens, 20s, 30s, 40s, and 50s, when we had formal redlining by the government not offering financing for residential development in certain areas if it meant that there was going to be integration as opposed to segregation. It's the history of restrictive covenants of individual homeowners not selling their homes to people of color in order to keep suburban and outer ring urban communities white, and everybody, the people of color who lived closer to the urban core, keeping those communities there and not allowing them to move too far away. So we know why, we have the composition that we have in our urban centers and in our densely populated urban areas, metropolitan areas generally. But environmental justice isn't just about those urban populations that are often communities of color. It's also about low-income white populations in rural areas. It's also about Native American populations, either on reservation or off reservation. It's also about the community of persons with disabilities, who of course are dispersed among all kinds of these other communities that I'm referring to right now. It's also about limited English proficiency communities, immigrant communities, the actual immigrants or the children of immigrants who are here, who are not yet English proficient, but who need to engage in these environmental processes. So we're talking about all those communities when we're talking about environmental justice and injustice. And so really, we're talking about the entire country. We're talking about application of law and policy to very broad swaths of the American public. And so that's what I mean by environmental justice community. So again, just to make it to revisit this one more time, the burdens are too close to those communities. The benefits are too far away for all kinds of historical and present day reasons. And so environmental justice law, or the environmental justice legal framework, is designed to address those environmental injustices, the fact that burdens are too close and benefits are too far. That's what environmental justice the environmental justice legal framework, at least in the United States, is designed to address and resolve. As I mentioned, there's no single federal statute that does this. But here's what exists. We have a number of legal frameworks that have three main aspects to them. They have procedural aspects, distributive aspects, and sometimes reparative aspects. So they have procedural aspects in the sense that they require a certain process. Think of an environmental permit like a Clean Water Act permit issued by the Environmental Protection Agency. There's going to be a publication of a draft permit. There's going to be an opportunity for people to review that draft permit and comment on it. There are going to be different stakeholders. There are going to be people within the agency, people from different agencies who are interacting with the EPA, and then people from outside of those agencies, business, public advocacy organizations, et cetera, who are also part of the process. So we have to make sure that there's a procedural component, and we have to make sure that there's procedural fairness when we're talking about an environmental justice legal framework. There's also a distributive aspect to it, which is you can have all the great procedure that you want, but the question is, are we still issuing permits that authorize polluting activity in neighborhoods and populations that are already overburdened? Are we still placing environmental benefits or deciding to repair or restore environmental benefits that are too far away from those communities? So if the outcomes are still bad, then all the procedure that you wanted, doesn't necessarily lead to better outcomes. So we want to make sure that the procedure is there, but we also want to make sure that outcomes look different. Those are the two main, component parts. And then sometimes some environmental justice legal frameworks will offer a reparative aspect. So when I say reparative, what I mean is Process and distribution, procedural and distributive aspects of environmental justice legal frameworks are usually project specific or site specific. They're about a particular permit, a particular facility, a particular park or forest. Reparative components of environmental justice law try to address those decades, sometimes centuries, of discrimination that led to the environmental injustice that that a community is facing today, and they try to lead to that reparative outcome by looking even more broadly than just the specific project or facility or permit at issue, and looking at restoring the community more generally. So I'll get into some examples of that a little bit later. But you've got procedural and distributive aspects for sure, and then sometimes you have reparative or restorative aspects as well that refer to more structural change. So those are the features of an environmental justice legal framework. Now let's get into specifics. So what are the different environmental justice legal frameworks that come together to form the broader environmental justice legal framework? There's anti-discrimination law. And so this is essentially civil rights law. Everybody's heard of these laws, but they haven't necessarily thought of them in application or in the context of environment and natural resources. So you have all of your civil rights laws. You have the Equal Protection Clause of the federal United States Constitution, and then you have laws that were largely passed in the 1960s and 70s that, that address civil rights. You have personal injury frameworks. So this is tort law, right? Everybody's heard of this before. Somebody trespasses on somebody else's property, they can be sued for that. Somebody, hurts somebody. Maybe there's a facility that is making too much noise and it's keeping everybody up, or producing too much light pollution, and it's not allowing anybody to, enjoy their own property. There are torts like nuisance and negligence that that come into play, where people can sue others to resolve their disputes. There's environmental law, right? We have all kinds of environmental laws: the Safe Drinking Water Act, the Clean Water Act, the Clean Air Act, et cetera, that can be used. Those environmental laws, mind you, are not about environmental justice. They never had environmental justice in mind. It's just that they're tools that can be used for environmental justice ends. You've got administrative law, right? We have a lot of our legal structure today is administrative in nature. You have federal and state agencies making decisions, issuing permits, investigating people, enforcing the law against people. And so you've got agencies making decisions, and you've got people who want to challenge those agency decisions. And so that's all administrative law. You've got contract law. Imagine settlement agreements between a community and a nearby company where they try to resolve their environmental dispute in some way. Or maybe you've got, in some cities like the city of Detroit, you have requirements for community benefits agreements where certain new industries have to actually come to agreement with the host communities to make sure that the host communities are receiving adequate benefits if they're being asked to accept the burden of those industries, moving in. So you've got all kinds of different frameworks: contract, administrative, personal injury, anti-discrimination or civil rights, environmental law, all different legal frameworks, none of which were ever designed for environmental justice, never designed to produce environmental justice, but can be utilized as tools to lead to environmental justice where there's already an environmental injustice. So let me just provide some concrete examples. I want to make sure that I leave plenty of time for questions, so I'm just going to move through these before I get to the Great Lakes portion. When it comes to civil rights laws, there are, for one kind of civil rights law is the Fair Housing Act. And there are communities out there that are trying to use the Fair Housing Act, which is really about making sure that there's no discrimination in obtaining a house, but also no discrimination, especially when it comes to houses that are maintained by landlords, or houses that are sold to people without the proper disclosures, to make sure that housing transactions are fair and that people are not discriminated against in housing transactions. And one of the interesting things that people have been thinking about when it comes to the Fair Housing Act is when it comes to lead in drinking water pollution. We're talking about lead, which is part of housing infrastructure, right? It's part of the house. It's one of the component parts of either a multi-unit dwelling or a single-family dwelling. And people are thinking of ways to use the Fair Housing Act, which is one of the civil rights laws, to make sure that people who are involved in developing housing and in transacting and providing people homes are not providing people homes that are going to poison them in the future. Or if you think about something like the Equal Protection Clause, the very early days of environmental justice law was really environmental justice civil rights litigation, where a lot of communities, especially in rural areas, actually, were suing their county governments or local governments or sometimes state government for placing too many landfills and too many other waste management facilities in communities that were largely communities of color. And in many of these counties, it seemed like whenever there was a new landfill proposed, it was going next to a Black and brown community and not in a community that was largely white or largely middle or high income. And so people were using the Equal Protection Clause of the United States Constitution to say, we're not enforcing the laws equally, right? We're not permitting in a way that's equal and fair. Some communities are getting overburdened by these toxic facilities and others are not. And actually, in many ways, it's civil rights litigation that created what today we call environmental justice law. Now, a lot of what I'm going to discuss in about 10 minutes is really going to be a lot more pertinent to you all, because it's going to be about what the federal and state governments do with policy, especially through administrative channels, and how research can feed into that. But environmental justice law got its start really as civil rights litigation in the 1980s, mainly by communities of color that were feeling overburdened by the siting and permitting of waste management and other polluting facilities near them and not near other communities that were better off. Now, in the 1990s, something really significant happens. President Clinton signs Executive Order 12898. Now, this takes environmental justice law from being a litigation framework, right, an area of law or an expression of law that's about resolving disputes in court by one person suing another person, often communities suing the government, but sometimes communities suing private companies as well. This environmental justice executive order in 1994 really took environmental justice law from being exclusively in the courthouse and mainly tied to civil rights and tort litigation, and converted it into administrative policymaking and administrative litigation. So here's what Executive Order 12898 did. It did two things really. First, it directed the federal agencies, because remember, an executive order from a president is simply an order from the person who employs the people in the federal government. So it's the president saying to the federal agencies that he or she supervises, I want you to start behaving differently. I want everybody, every agency, by the way, not just the environmental agencies, the Department of the Interior, the Environmental Protection Agency, but every other agency, Housing and Urban Development, and the Department of Defense. I want every agency to think about how, through permitting, through policymaking, what you are doing to either exacerbate environmental injustice or to achieve environmental justice for the environmental justice communities. Now, one difference between the executive order and the traditional civil rights laws that were used before it, the civil rights laws are mainly about race and national origin. So they're really mainly focused on communities of color, but also on persons with disabilities, because we have a whole other set of laws like the Americans with Disabilities Act that focuses on those communities. What the executive order does differently in 1994 is it adds low-income communities. To be clear, low income remains a category outside of the civil rights framework, but now all of a sudden, the low income category is part of what the federal government does when it thinks about environmental justice. So it's not just thinking about communities of color, Native American communities, the communities of people with disabilities, but it's also thinking about low income communities, no matter race, national origin, et cetera. So that environmental justice order, first of all, tells the federal agencies to all do a kind of audit of how they're doing on environmental justice and injustice, and to come up with a plan to do better. And it also reminds those agencies, those federal agencies, that they have an oversight responsibility over the state agencies to whom the federal government gives money. So anytime the federal government gives money to a state or local agency, or for that matter, a private partner, anytime the federal government gives money, of course, it's given with some strings and conditions. And one of those strings and conditions is compliance with our civil rights laws. So what this executive order does is it reminds federal agencies that as part of its civil rights oversight authority, making sure that state and local agencies who receive federal dollars are complying with civil rights laws, it basically reminds those federal agencies that there's an environmental component of civil rights. And that if those state or local agencies are not doing what they need to do to achieve environmental justice, which is the environmental component of civil rights, then the federal agencies can investigate that and make sure that those state and local agencies come into compliance. I'll just give one quick example of this work. As I mentioned, national origin is one of the focus areas of civil rights law. And so what national origin means in the environmental justice context is if you have decision-making happening by environmental agencies or natural resources agencies, if decision-making is happening, permits are being issued, or decisions are being made about who's going to receive a kind of license or authority, or decisions are made about which park gets expanded or which fishery gets improved, that there has to be translation if certain communities that have limited English proficiency are going to be impacted by that decision. Now, there are other criteria that I'm not going to get into, but broadly speaking, we want to make sure that from a procedural justice perspective, that those limited English proficiency communities are brought into the process and fully understand the decisions that are going to be made, the implications of those decisions for their communities. So, imagine, I'm working on a case right now, imagine, for example, that you have a state agency, like a Department of Health, that knows that a particular river has fish that should not be consumed by humans because those fish are just, they just contain too many heavy metals, too many PFAS chemicals, too many, et cetera, et cetera. And so they want to issue a do not eat advisory for the communities who fish, those rivers. Well, imagine you have a situation where a number of people who fish in that river are people of different, national origins who don't speak English proficiently quite yet. They need to understand that do not eat advisory. And if it's not translated into their native language, then they're never going to know that they can't fish in those rivers and consume those fish. And so if the Department of Health in that state is not doing its job by not translating for that community, somebody can make a complaint to the federal Department of Health and say, you have oversight responsibility over that state agency because that state agency receives money from you. And that state agency is not fulfilling its civil rights obligations because it's not creating these translations. But of course, all of this is in the context, right, of, in this case, natural resources and justice. So you can make a complaint to that federal agency can investigate and can probably work with that state agency to bring it into compliance by telling it to translate those advisories. So that's just a quick example of how that oversight works. That's what the executive order from 1994 did. And what it has done basically is it has instructed every federal agency, including NOAA, to make sure that it considers environmental justice in its decision making. Not only does that empower those federal agencies to oversee their state and local financial money financing recipients, but it also means that when those federal agencies themselves make decisions, those decisions, if they do not sufficiently consider environmental justice implications, can be challenged legally, by people in the community. So another quick example of that, let's say that the Department of Interior is working on a revision to a national forest plan. It wants to, manage a particular national forest very differently than the way it's managed it so far. And when you're managing a national forest, you're basically managing, resource allocation. How are we going to make sure that people who want access to hiking can hike while also allowing people to develop oil and gas resources, while also allowing companies to harvest timber for timber resources, while also making sure that the watershed is protected and is producing a healthy fishery. How can we make sure that all those things are happening and getting balanced? All those different competing uses are balanced. Well, imagine that the revision to that National Forest Plan doesn't sufficiently account for persons with physical disabilities who want to use hiking trails, who may need motorized access to those hiking trails. But if the revision doesn't provide that motorized access, then there's a real issue there. Or imagine that you have certain Native American cultural resources that are very significant, and those are being ignored by the federal agency. When they do their environmental assessment or environmental impact statement, which they're required to do under the National Environmental Protection Act, if they don't sufficiently consider those environmental justice implications, then their NEPA document, their environmental assessment or environmental impact statement, can be challenged by the aggrieved community. And so the executive order by President Clinton and then future iterations of this signed by Presidents Obama and Biden have done a lot to create a huge administrative focus on environmental justice law, so that it is now infused in every federal agency. And then because of the way federal funding works for state and local agencies, now is also infused in those state and local agencies. So environmental justice from 1994 has become a part of every level of government decision making, or at least needs to be. And if it isn't, there's an issue. So now let me talk about the Great Lakes region and what's happening around the Great Lakes region, and why we need to all be paying attention to this. It's happening anyway all around us, but the more we pay attention to it, the more we'll understand how to positively feed into it. So what form, does environmental justice take? Well, let me actually say that one form that environmental justice can take, it hasn't taken this form yet in the Great Lakes region, but it's taken it recently in places like New York and New Jersey, is actual environmental justice laws. So not other legal frameworks that can be used, instrumentalized to achieve environmental justice ends, but instead state statutes passed by state legislatures that are actually focused on environmental justice problems. So for example, in New Jersey, you have an environmental justice law that has some interesting provisions. For one, it says that if a activity is going to be authorized by the state government in an area that has an environmental justice community, and there are real implications for that community, because maybe this is a polluting resource, or maybe this is a kind of environmental benefit, like a forest or park, but that's being located too far away. The comment period for that decision making, where the public can actually comment, is longer. The idea is those environmental justice communities are overburdened communities. Those are communities that have people in them that probably there's a higher likelihood that they're working 2 jobs, not 1, or 3 jobs, not 2. And that they're probably working different hours, and that they're probably working jobs that are, more blue collar and physical labor is involved. And we need to figure out how to make sure that they have more time to not only comment, but also to, find organizations who can champion their cause, and maybe file more technical comments on their behalf. So you have longer public notice and comment periods because of that law. You also have, that'd be the procedural justice side of it. You also have a distributive justice aspect to the New Jersey law, which is, if we're gonna go ahead and permit an activity in an otherwise overburdened community, we wanna make sure that the person receiving the permit, the company receiving the permit, implements mitigation measures to even to mitigate, the kind of harmful pollution that might result from it even more. And so let's say, for example, you have a facility that's going to set up shop, a big manufacturing facility that's going to put out, air pollution. It's not just the air pollution that's an issue. That facility may receive a lot of visits from trucks, because maybe there are a lot of raw materials that have to get to that manufacturing facility, and there's a lot of truck traffic. So we're going to see in a community in New Jersey mitigation measures having to be taken by that facility that receives the permit, to make sure that the surrounding community is not overburdened by the air pollution from the facility itself, but also the air pollution from the truck traffic that goes to the facility and gets at its raw materials. So there is the capacity at the state level for actual environmental justice laws, and we're seeing them outside of the Great Lakes region, and maybe we'll see them in the Great Lakes region. But let me talk about some of the concrete things that are already happening in the Great Lakes region. First of all, pay attention to governors. Governors are issuing their own executive orders, instructing their own state agencies to better consider environmental justice when it comes to permitting, standard setting, siting, of facilities, enforcement against violators. And so, for example, in Michigan, you have Governor Whitmer signing an order that creates an entire environmental justice office within the state environmental agency that's meant to work with other agencies in an interagency, interdisciplinary fashion to make sure that we can achieve environmental justice across the state of Michigan. You have the governor in Wisconsin issuing an interesting forest management order that requires that environmental justice and climate justice be considered when managing our forests for all different kinds of reasons. You've got state attorneys general, right? The main legal enforcement officers of every state doing all kinds of interesting things on environmental justice. For example, when they look at the many different, violators in the state of environmental laws, they're prioritizing those violators that are violating environmental laws and impacting environmental justice communities and trying to enforce against those violators first before they enforce against other kinds of violators. The Federal Department of Justice does this, and many state attorneys general do it, including within the Great Lakes region. You have state agencies doing a lot of interesting things on environmental justice. In Michigan, for example, the State Environmental Agency a few years ago published its first ever limited English proficiency policy, where it was very specific about when it would translate at public hearings and when it would translate documents in languages like Spanish and Arabic, which are the predominantly spoken non-English languages in the state of Michigan. And you have you have agencies in other Great Lakes states doing the same. Take, for example, the revolving funds, the Safe Drinking Water Revolving Fund and the Clean Water Revolving Fund from the State Safe Drinking Water Act and the Clean Water Act. These are basically the financing mechanisms where the federal government gives money to the state agencies to then distribute, to local water management agencies who deliver drinking water, who do wastewater treatment, who do stormwater management. Those communities are applying for these grants and loans, often low interest loans and forgivable principal loans. And we have state agencies rewriting their criteria for distribution of those loans and grants to make sure not only that environmental justice communities are receiving them, but to also make sure that once they get them, they can actually implement something with them. They're not just getting money, but they're too understaffed, to do anything with it, that they're actually empowered to do something with those monies once they receive them, and to also streamline the request process so that they're able to actually access the money, apply for the money in simpler and easier ways, understanding that they're not going to be staffed for applying for that money all the time. And so you've got the revolving fund departments and units within agencies totally rethinking their criteria across the Great Lakes region. You have within, for example, the Great Lakes, I'm just going to switch to my other notes here. You've got the Great Lakes Restoration Initiative, of course, which provides a lot of money within the Great Lakes region to address problems in areas of concern. And what you have now, and it's mainly at the project level, but it is being driven by policy that resides higher up. You have a lot of extra focus on environmental justice communities. One quick example that my research assistant, dug up. You have, for example, in the Ohio Environmental Protection Agency, implementing the lake-wide action management plans, right, to deal with HABs and other kinds of pollution in Lake Erie. You have environmental justice and climate resiliency at the forefront there, and you have lake action management plans and AOC programs where they are prioritizing communities of color and other environmental justice communities to make sure that those communities are first in line to receive the benefits of the actual implementation work that's done once the state agency receives the GLRI money and can actually perform a project with it. So you've got a lot of coordination to identify those communities and to make sure that resources get to them first. And this is being driven by higher level policy that's making its way down into the site-specific project level within the Great Lakes Restoration Initiative program. You have permitting standards. You have agencies that are interpreting their environmental laws and their gubernatorial executive orders to account for things that they weren't accounting for before, such as cumulative impacts. What do you do when you are considering the permitting an air pollution facility in an area that is already receiving multiple sources and multiple kinds of air pollution. And if you considered each of those sources, each of them might comply with the law individually, but when you combine those pollution levels together, you know that you have an overburdened community that can't possibly breathe in any more pollutants. So how do you account for those cumulative impacts when the Clean Air Act doesn't expressly tell you, that there's a way to do it? Well, you've got some creative interpretations, legitimate and reasonable interpretations of laws at the state level within the Great Lakes region that are accounting for those cumulative impacts, so that we're not further overburdening already overburdened communities when it comes to air pollution. You have interesting, projects. I'll go back very briefly to the Great Lakes Restoration Initiative, because there was a project I wanted to make sure to talk about here. You've got a project, you've got a focus, for example, in Indiana and Wisconsin on fisheries resources and trying to incorporate traditional ecological knowledge from our Native American communities so that we can better understand how to manage a fishery by bringing in the community of people who have been managing that fishery, who were managing that fishery for thousands of years, in pre-colonial history, bringing that community in from a procedural perspective and making sure that we are accounting for their knowledge of the ecology as well as the agency's knowledge of the ecology to either co-manage the fishery or at least account for their ecological perspective when the agency manages the fishery or makes a decision that will impact management of the fishery. So you've got that happening in different states in the Great Lakes region. So the executive order from 1994 is, I think, the thing to focus on really, because we continue to have environmental justice litigation. We continue to have communities suing government agencies and suing private developers and other private companies for violation of either our civil rights laws or our tort, personal injury laws to achieve environmental justice. That has been happening for decades. That will continue to happen, and it's a necessary component of the overall environmental justice legal framework. But what happened in 1994 should really be considered earth-shatteringly important. It really made environmental justice law into administrative law. And it meant that now environmental justice was going to be considered as a civil rights component, and it was going to be considered across federal agencies, and again, by state and local agencies, either because the states themselves wanted to do that or because they were being overseen by the federal agencies because they'd taken their money. And so now you've got civil rights considerations, in the environmental context, infused within the federal, state, and local governments, and it's applying at the different agencies. So we're seeing it from the different departments in the executive branch, including the enforcement branches, the permitting branches, the investigatory branches, the funding, resource allocation branches. We're seeing it obviously at the different federal levels. We're seeing it in the courthouse still, and we're seeing it in the institutional space, right, with the creation of environmental justice offices or bureaus or divisions or units who are meant to have a focus on environmental justice within an agency and also bring in perspectives from other agencies to work in an interagency, interdisciplinary manner to achieve environmental justice across state offices. It's a little bit like a health and all policies approach. This is essentially an environmental justice and all policies approach. And that really started in 1994, and that lives with us today. And that's why it's so crucial to think about research and science in the ecological arena in the context of this administrativization of environmental justice law. Now that we have the federal, state, and local governments all thinking about it, they're thinking about it at every stage of the decision-making process. They're thinking about it as early as standard setting. They're thinking about it as late as project implementation, and they're thinking about it everywhere in between. So that when you've got, for example, the state of Michigan or any other state in the Great Lakes region, thinking about how it's going to issue stormwater management permits, there's an argument to be made that the flooding considerations are not just flooding considerations in the abstract, but considerations that have to do with environmental justice populations that of course reside in areas with built infrastructure that cannot handle flooding, as well as other built infrastructures can in newer suburban areas and in revitalized urban neighborhoods. And the idea is that those flooding permits and flooding authorizations have to account for the fact that we have variable ability among communities to deal with that flooding. And if we don't have the science and the research to understand how Southwest Detroiters are going to endure flooding differently from suburban Ann Arborites, then we're never going to be able to solve the permitting dilemmas and the enforcement dilemmas that are related to that. And so I think that understanding the environmental justice legal framework, of course, has implications not only for policy and advocacy professionals, but I think increasingly for research and science professionals too. So at 1:47, I think I'm going to take a break on talking and then hear from you all if there are any questions in the room or any questions online.
I'm stuck in this term of considers environmental justice. So to go back to an example you used, if the DOI is implementing a trail in a forest, and they say, well, we considered the possibility of making the trail wheelchair accessible, but they didn't actually implement that. Is that a good enough argument, or do they have to actually go ahead and implement that?
Okay, yeah, it's a great question. So, in every legal context, it's going to be a little bit different. So, for example, in the context that you're talking about, there's going to be something like an infeasibility or impossibility defense, right? Like in some circumstances, it's just going to be impossible to provide for motorized access and still have the balancing that you wanna achieve. So what I'll say is, if the standard for environmental justice, if the standard to protect the integrity of persons with disabilities didn't exist at all, well, then there'd be no consideration of it, and decisions to include motorized access or other forms of accessibility or not would be up to the whims of the particular agency officials in charge of it. But because the standard exists, that means a few things. One, it means that the agency has to consider alternatives. It has to consider, how can we do this in a way that's accessible, and how are we going to do it in a way that's inaccessible, and it has to make a choice between those two things. And then the law itself provides for enforcement potential, right? So, I mean, it's good enough that people have the ability to comment. Sometimes commenting and putting something out there transparently in the public is enough to convince an agency to do a better thing for a particularly disadvantaged community. But if that's not enough, and if that disadvantaged community, if that community that's aggrieved by the decision to have an inaccessible trail, a non-motorized trail, or inaccessible in some other way, if they're aggrieved by that decision, well, there's a law in place that provides them an enforcement mechanism where they can go into court or maybe go into an agency tribunal and say, this agency didn't consider it enough. Not only didn't they consider it enough, in some cases it'll just be a matter of not considering sufficiently, but even if they've considered it sufficiently, sometimes the agency just makes the wrong decision and violated the legal standard and should have put in the accessible motorized trail instead of the inaccessible non-motorized trail. So sometimes they'll win and sometimes they'll lose, but it's not just about consideration. Sometimes it's just about consideration, but sometimes it's actually about implementation and outcomes. It'll depend, again, on the specific law. In this case, right, you have the Rehabilitation Act and the Americans with Disabilities Act, two different federal statutes that might be implicated here. But across different civil rights frameworks and other legal frameworks, you might have very different kinds of decisions being made. So it does depend. It's a little bit statute specific, policy specific, but in general, it's not just about consideration. It is also about outcomes.
Yeah, thanks for doing this great talk. I was curious about the distributive impacts of environmental degradation or environmentally unjust actions if there's state implementation or consideration at the state level of EJ concerns. And so let's say there's, I'm thinking about like Line 5, for example, right? There's a lot of challenges, local challenges, legal challenges to Line 5, which could enable or just allow Enbridge to just move elsewhere. And so I was curious, what your perspective is on, when there are more efforts in certain areas over time to implement EJ law, how that might concentrate environmental injustices or like environmental degradation in areas where there might be, fewer efforts to use EJ law to sort of challenge those issues.
Yeah, I mean, you happen to choose an example that where you have an oil pipeline that's going to sit across a lot of different territory, right? It's going to cross state borders, it's going to cross county borders, it's going to go through Native American reservations. It's a geographically large enterprise, and so your question makes sense in that context. Of course, there are many contexts, right, where you have small facilities or small projects that are going to be isolated, within a particular area, and you're not going to have those same trade-offs. But Line 5 is actually an interesting example. I mean, full disclosure, I've worked on Line 5 for a number of years now. Mike and I have the scars to prove it. But one example of the use of tort law in this case, or property law in some ways too, in order to achieve an environmental justice end, is you have the Bad River Band, which is an Indian sovereign nation that sits on the Lake Superior shores within the state of Wisconsin, who for a long time had Line 5 running through their reservation because of decisions made, yes, by prior tribal councils, but largely because in the United States legal framework with regard to Indian nations, too often the United States makes decisions on behalf of Indian nations, and that's been the system for a very long time. Unfortunately, is that the federal domestic government makes decisions on behalf of Native Americans because the government thinks it knows best, and that's the history of the relationship between Indian nations and the federal American government is long, and I think folks know probably a lot about it. But in any event, but the decision was made by a contemporary council that it was no longer interested in renewing the easements, the property instruments that allowed the line to cross the reservation. It was no longer interested in renewing those easements. They didn't want to live with the risk of environmental disaster and of changing their entire way of life and of threatening their fishery and their watershed ecology. So they made the decision not to renew. Enbridge didn't leave, and so the tribe sued them in court. Full disclosure, I represented the tribe, in that lawsuit. I was one of many attorneys, and I did little work compared to them. But they used those tort laws to good effect, right? I mean, they are essentially on their way to forcing Enbridge to go around the reservation at the very least, and not be able to go through it. But elsewhere, as you say, down the line, right, in other places in Wisconsin and in Michigan, you have very different issues. You have very different community responses. You have very different legal frameworks, that apply. And so, I mean, I guess all I can say to your question is that it's when you have when you have an environmental risk that exists in many communities all at once, you are going to have different responses, but a lot of it is going to depend on the legal framework that you're relying on. The Bad River Band was able to rely on the tort and property law framework because that's the tool that it had at its disposal, and it made sense in that context. But as you get into the state of Michigan, you just had the Michigan Public Service Commission, for example, say, that the replacement line, the one that's going to go, supposedly below the Straits of Mackinac, meets the public need and is going to be, safe enough, et cetera, et cetera. Very different legal framework, very different legal considerations, different opportunities, maybe not as good for marginalized communities to get involved in the process, procedurally speaking, and to achieve the distributive outcome that it wanted. So, when you have an environmental risk that impacts so many different communities, it's a lot of different laws and jurisdictions are going to be implicated, and it's just going to look different everywhere. So. Wait for the microphone, sorry.
Thank you. You mentioned the GLRI and communities or states or, starting to think about environmental justice in the GLRI, but it strikes me that that's usually just like something that they choose to do, not something that has any type of policy mechanism. So by the same token, if they don't want to do it, they just won't. I'm wondering if you could speak about that at all and why GLRI is excluded from Justice 40 and if that matters.
Yeah, it's a really great question. Here's what I will say. First of all, I'm not sure that the premise, that I accept the premise entirely, although I agree with you that that's the perception, right? Is that something like the GLRI is, the way you described it's a little bit like how some people describe obligations under international law. Every state does what it wants to do and it complies with international law if it's in its interest, and it doesn't if it isn't. But I do think it's different actually, and here's the way that I would put it. The executive order from 1994 and every subsequent environmental justice order signed by Presidents Obama and Biden later on make it clear that every federal agency must not only consider but actually implement environmental justice policy. Every agency has an environmental justice plan, after all. Some of those plans are more outdated than others, but every agency has one. And then, of course, state agencies, either according to state law, gubernatorial executive order or state statute, or according to fear of federal oversight, right, and making sure that they're not out of compliance with those civil rights obligations, has those same. So what I'll say is, if that funding, because it is a funding law, right, it's an allocation. If it's not expressly about environmental justice, you're right. It's just money going to somebody. But the minute that money lands in an agency, and if any agency, federal or state or local, has to make a decision about the use of that money, where it's going to go and how it's going to be, utilized towards some environmental, end, then environmental justice must be a part of the decision-making process. Now, the question is, who's going to make sure that that's understood and that's actually implemented in the way that it should be? Sometimes, as you say, agencies will just wake up in the morning and do the right thing. State governments, local governments will just wake up in the morning and do the right thing. But sometimes they have to be convinced to do the right thing. So this is happening already voluntarily. I mean, I say voluntarily, what I mean by that is it's happening not because of any outside pressure per se, but because they're just getting up in the morning and doing it the way they should be doing it. But if that's not happening, if, for example, GLRI money is, going, if it turned out that GLRI money that was going to particular areas of concern within a state seems to always be going to those sub areas within an area of concern that are not environmental justice communities, that are better off communities, that don't need the extra help perhaps, that are privileged already. If it turns out that it seems to always be making its way there, and seems to always be making its way to projects that are not benefiting communities that are suffering from historic environmental injustice, then I think there is an actionable grievance there. I think environmental justice communities can complain about that, and there are multiple outlets for complaint at the local, state, and federal levels. And I think that there could also be, litigation involved. And so I think that I don't accept the premise, that the GLRI, just because on its face it may not mention it, isn't obligated to consider and implement environmental justice. It is. The question is, how do you make sure that it's done? Sometimes it's done internally and organically within government processes. Sometimes you need outward pressure, but I think that the standards exist, that the requirements exist to make sure that environmental justice is done by the GLRI. But you would need an example, first of all, of lack of fairness and equal treatment, right? Before it can actually be actionable. But no, I think it's there. I just don't think it's as express as it may be in other areas of the law.
We're going to leave it there, but thank you, Oday. Thanks for coming.
You are. Yeah, thank you.